The best defense is a good offense. Debt law and motions for summary judgment. Brought to you by yourlegallegup.com, your advantage if you're being sued by debt collectors. If you're being sued for debt, your case will head for a showdown on a couple of main issues. It will probably involve some billing records or record keepers wanting to testify. And these are primarily legal issues, that is, facts that can be clear and undisputed, and the judge might be able to make a decision about the case. When a judge does that by motion and before trial, it's called a summary judgment, and the parties ask for that by filing a motion for summary judgment. You will want to consider trying this. This video will discuss how it works briefly, and in the video description below you will find a link to much more information if you need it. Before we go deeply into motions for summary judgment, let's discuss the way cases develop, go away, or are decided. It's really just one process. First, the parties conduct discovery, which aims to find out what facts are indeed uncontested, that is, what you can prove about your case or their case. Debt law is pretty simple that way. In debt law, you either want to prove it was all a horrible mistake, if that's what's going on, or that the debt collector cannot prove its case. Since most debt cases come from what were at one time legitimate debts, most debt defense boils down to an attack on the debt collector's case, and you will have an excellent chance of winning on that basis. Of course, if the debt never had anything to do with you, you'll want to attack on that grounds, right? In your discovery, you will probe for what evidence they have and how they plan to get it into evidence, i.e. into the court's consideration at trial. And there are rules about that. As facts emerge and as work on the case happens and becomes necessary, the debt collector might decide just to drop the case. In fact, that often happens, but of course it often doesn't happen too. Sometimes in debt cases, the debt collector will try to shorten things up by a motion for summary judgment, but more often, it seems they just want to get to trial as quickly as possible. That's the easiest, fastest way for them to get, to get to judgment. If they do that before you have conducted your discovery, there's a good chance you will be snowed under, and that's part of why we tell people to get on with the discovery part of the case ASAP. You want to aim for the motion for summary judgment right from the very first time you file your answer and discovery. Now, to talk more specifically about motions for summary judgment, a motion is just a formal way you ask the court to issue a ruling of some sort. A motion for summary judgment is asking the court to find that you have shown all the necessary facts for a ruling in your favor and to grant you a judgment. Motions for summary judgment are evidentiary motions, and that is, as part of the motion, you present evidence to the court. Not just anything, it must be admissible, allowable for the court to consider just as if it were a trial, only by affidavit or other written form rather than live testimony. And the evidence must be uncontested. That doesn't mean that everybody has to like it or agree with it. Evidence is only contested if there is other evidence suggesting that it isn't true. Conflicting evidence means that the court would have to decide which is true and which is false, and that's supposed to happen at the trial stage. On motions for summary judgment, conflicts in evidence should be decided against the party bringing the motion. Losing a motion for summary judgment doesn't mean you lose the case. It means that a trial is necessary to decide who wins. It's possible to get a summary judgment about some parts of a case, but not others, a partial summary judgment in legalese. To end the case, though, you have to get judgment on all of the claims. In other words, if they've brought a case in 2 counts, you have to prove that they can't prove either of those counts, obviously. Otherwise, they still have something to take to trial, right? So here's what to do. If you're being sued right from the beginning, you should think long and hard about what it takes to win your case. In debt law, the first big challenge most defendants face is to answer the petition, just to take that first step in defending yourself. If you've managed that, congratulations. Just by doing that, you've given yourself a better chance to win than approximately 90% of the other people being sued. That's obviously, we're not talking about a motion for summary judgment there, we're just talking about answering the petition. And in some cases, to be sure, that's all you need. The debt collector may walk away right at that stage. I mean, they're looking for easy money. But in most cases, they won't. So your next specific step is to start discovery, and the sooner the better, as I said before. And you should start discovery with the firm goal of finding and proving the things that you need to win. Nothing about your case is or should be random, although part of what you're doing is trying to find out what you need to know. So there's a certain casting of the nets that won't necessarily, you won't necessarily know what you're going to get at all times. In a way, it's simple, although this is one time you should never confuse simple with easy. If they're alleging a breach of contract, for example, you will find that they must prove the existence of a valid contract, its breach, that is, failure to pay as agreed, and damages. The burden of proof is on the debt collector for each of these things, and they have to show it using admissible evidence. In your discovery, you should have narrowed down exactly what they have to offer as proof. In the case of a debt collector, this is usually documents created by some other person, usually the original creditor, and they may have documents or testimony by some of their own employees as well. These things are generally intended to try either to fool the court into believing their documentary evidence, bills with your name on them, is admissible, or to pull the documents within the rules of evidence. Your job will be to look at each bit of evidence and show why it can't do what the debt collectors wanted to do, or why the court's not allowed to consider it. Of course, this isn't very easy, and there are significant procedural requirements that differ from state to state, but going through this process improves your chances of winning dramatically in 3 important ways. First, if you can show your right to a summary judgment, you should win the motion and get the case kicked out. Before that happens, though, you will be putting the plaintiff to the expense and effort of responding, and if they think they will lose, and often even if they think they will win, they'd rather just drop the case and keep going. And finally, even if the court does not rule or rules against you, you will have learned a tremendous amount about the law and begun the process of teaching the judge what he or she needs to know, improving your chances of winning a trial a lot. There is every reason to do it. You just need the energy and courage to try. We can help. Helping people protect their rights is what we do. Protect what's yours and don't let the debt collectors rip you off. Take action to protect yourself from the debt collectors. Help others do the same. Please like this video, share it, and subscribe and comment, as all these things help other people find our materials. yourlegallegup.com